Hello. Data protection and privacy is on everyone's mind today. So today we're going to talk about the General Data Protection Regulation put forth by the European Union. The European Union is made up of 28 countries, and they have established this regulation for several different reasons. One is to harmonize, in the United States we'd say standardize, data protection regulations across all of the European countries. Secondly, it is to protect European citizens' data, but also to empower European citizens to control how their data is being used. And finally, it establishes a long list of rules and regulations for companies that are going to be controlling and processing European citizens' data. So what we're going to talk about today, we'll go over a few definitions so you understand the words that they use in the GDPR. We're also going to talk about who it applies to, enforcement of GDPR, data subjects' rights, obligations for data processors and controllers, what the lawful basis is for processing, some consent requirements, and also we'll give you some steps that will help you with your GDPR compliance. Throughout the presentation, you will also be seeing some evidence of some of the pages from the GDPR itself to back up some of what we're telling you. And also we'll have some examples of some best practices that could help you out as well. So some basic terminology for GDPR. First off, personal data. Personal data is any information related to a natural person or data subject that can be used to directly or indirectly identify the person. And that can include things like the name, a photo, an email address, even posts on social networking sites, of course, bank data and medical information. And finally, even a computer IP address is considered personal data. Next is the controller. So the controller is a company or person that controls how that data is going to be collected and used. I think of it as the company that might write the program for collecting data because they'll determine what fields are going to be gathered and how they'll be used. The processor is the company that processes the data that's been collected, and they're under obligation to follow the rules that the controller has outlined. The data subject is the person who the data relates to. Harmonize, as I mentioned, is the same thing as standardize in United States terminology. And subprocessing is equal to third-party processing in United States terminology. Now, the Data Protection Authority and the Data Protection Officer are some of the roles that will be ensuring that GDPR is enforced, and I'll show you a little bit more about that in just a short time. So Article 4 of the GDPR provides many definitions related to GDPR itself. There are approximately 28 definitions in there, and if you want to see some more definitions, you're welcome to read those. For this presentation, in the interest of time, we're just presenting some of the high-level ones to help you understand what we're talking about here. So this slide shows you the GDPR enforcement structure. At the highest level, you have the European Union-wide, and that includes the European Data Commission, which is made up of the Data Protection Board. The Data Protection Board has an individual from each of the countries in the European Union. At the national level, you have the Supervisory Authority and the Data Protection Authorities. And then at the company level, you have the Data Protection Officer. Not all companies are required to have a data protection officer, but a lot of the large ones that process high volumes of personal data will be. So who does GDPR apply to? Article 3 establishes what the territorial scope is for GDPR, and the quick overview is that it covers, of course, any company that is in the European Union itself, And any company outside the European Union that offers goods or services to European citizens monitors European individuals, and that might include your law enforcement companies, any company that stores or processes European data. Now, companies that don't store European data could still be impacted because other companies are beginning to make changes to adhere to GDPR. And if you do business with another company that has to adhere to GDPR, it could change the way that you do business with them. So, for example, personal data collection is required to be limited in what you collect to be only that which is mandatory for the actual business purpose that you're trying to perform. In the past, in the United States, we collected a little bit of everything thinking maybe we'll need it someday. Well, that's not permissible under GDPR. Secondly, the storage of personal data has to be minimized in time. So if you used to get data from another company and that company is now restricting and limiting, it could affect what you're getting from them. So you'll want to talk to your partners, your business partner companies, and find out what changes they're making to adhere to GDPR. Now, another example is the ICANN, who is Domain Name Registry. Has already been brought up in some stories in the news because their usual way of processing information in the past had been that they required that anyone who registered a domain name gave public access through the WHOIS database. And now that's changing, and there are some exceptions to that, by the way. But because that is in the opposite of what GDPR wants to have done, ICANN is now saying that the database may be inaccessible for up to 6 months while they work through all the details of this, and that they are not going to hold companies accountable to their original contracts that stated that this information had to be made public. So that's something that the way it might impact you is if your business was filtering out websites that you didn't want coming into your company and it was going through the WHOIS domain, the WHOIS database, then that could change in the future. Another company that's already made changes to this is the GoDaddy website, which has changed how they use WHOIS information, and they've redacted some of the fields already to adhere to GDPR. So this is the whereas clause of the GDPR that states that PD collection must be limited and storage time must be minimized. So if you wanted to see the exact wording and the way that some of this information is laid out in the GDPR, this is an example of it. Personal data should be adequate, relevant, and limited to what is necessary for the purposes for which they are processed. So here's an example of a screen in which the controllers are giving the data subjects more control over their information. You can see here that they're allowing the person to select who can see my details, who can share my information, and what ads do I want. This is beneficial to most people because it enables them to select and choose how their information is going to be used. So let's talk about enforcement. Enforcement can take many forms. It could be as simple as a warning. They could decide that you have to correct data that's inaccurate. They could require you to delete information. They could assess fines, and the fines are extremely high. The fines can be up to 4% of your worldwide revenue, or 20 million euros, which is approximately the equivalent of right now 24.5 million US dollars. Whichever is the higher is the way it is worded in the GDPR. So needless to say, that's a pretty high amount of money. So the companies are paying attention. They are implementing GDPR and trying to adhere to it because they don't want to get hit with those fines. Also, they could say that you have to abstain from use of the information in the data, class action lawsuits, which were never done in Europe before, are now going to be available to them in GDPR. And finally, they could require you to compensate the individuals who are affected by a breach. Article 83 of the GDPR explains in more detail what the maximums are on the fines. Now let's talk about data subject rights. So GDPR grants explicit rights to access. An individual can ask a company to provide for them all of the information that they have on that individual in their database, and the company would have to produce it electronically. They can say that they have to correct something that's invalid or incorrect. They also have the right to erasure, which is known as the right to be forgotten. They can contact a company and say, I want you to remove this piece of information about me that's in your database. Now, the company has the right to challenge that, and depending on what it is, they may or may not get that taken out, but you have to provide that capability in your system. They could restrict how you use the information. They also, for breach notification, the company has to notify the authorities within 72 hours, and they have to notify the individual without undue delay based on whatever the authorities require. Data portability is that an individual can say, I'm switching to another collector and I would like you to transport that information over to them, kind of like what we do in the United States with healthcare. If you change doctors, one doctor can send the health records to another doctor. They can object to your using their information, and they can also object to automated decision making and profiling collection. So this is an extract from GDPR showing you Article 17, and it's quite extensive. It talks to the right to be forgotten. So you will want to read these in more detail because the presentation goes over it in a high level. All right, now here's an example of how privacy statements can be provided in layers. So if you were programming and you were feeling overwhelmed by the amount of data that you have to provide, you can't fit it all on one screen, a person can click on how will we use the information about you, and then it opens another screen that gives you some more information, and again they could open a further link that can provide even more information. Let's talk about obligations for data processors and controllers. First, the controllers. So controllers have to implement and demonstrate GDPR, of course. They have to adhere to codes of conduct which are established between the controllers and the processors. They also have to adhere to data protection by design and default. Very interesting. So when they're designing new software, they have to include data protection and GDPR requirements in the data software design, and the defaults cannot be left to an insecure state. So for example, the checkbox where an individual would check that they want to accept, it cannot be pre-checked. It has to be the individual checking it that activates it. If you have multiple companies that are going to be controlling the data, then those companies will need to have roles and responsibilities documents shared between them. That's similar to what we do today with payment card industry compliance. And finally, for large companies processing high volumes of personal data, they're going to need to designate a representative in the EU. This shows you the obligations for controllers are in Article 25 of GDPR. Now, obligations for data processors. First, you need to have a contractual relationship between the controller and the data processor. The data processor has to follow the controller's instructions, and the data processor is not allowed to establish a new subprocessor without getting authorization from the controller. Also, if the data processor decides to change the subprocessor, they would still need to notify the controller and get their approval. And they have to, of course, adhere to the code of conduct. Now, for companies that are above 250 employees, they have to keep records on their GDPR activities, and you'd want to keep a log of those. Companies under 250 employees are not required to do that. Next is data security. Of course, you have to keep your data secure, and that would include several different things. First, you would have to keep data encrypted. You have to include data security for risks presented by processing, by accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or processed. You also need to be resilient and make sure that you are able to recover from a failure. And for breach notification, again, you have to notify the authorities within 72 hours and the data subjects without undue delay. The data protection impact assessment is kind of similar to a risk assessment that we do here in the United States, although you want to do it with a focus on the GDPR requirements. And then again, you may need to assign a data protection officer under certain circumstances. So Article 32 provides more information on security of data processing. Lawful basis for processing. So in order to process personal data of EU citizens, you have to have a lawful basis for doing so, or express consent from the individual. The lawful basis may include that you either already have a contract with that person, or you're planning to engage in a contract with that person. It could be that you need to do it to comply with a regulation, either GDPR regulation or another one. Also, to protect the vital interests of the data subject, and I'll expound on that one more briefly in a bit. And then public interests of an official or authority, and legitimate interests pursued by the controller. So Article 6 of GDPR expounds upon the lawful processing rules. And this expands upon what is considered in the vital interests of the data subject. So if it's for humanitarian purposes, monitoring for epidemics, natural and man-made disasters. So for example, if you had someone in the midst of a disaster, you would not have to say, oh, give me your consent before I can process your data. It's a good thing. Now here's an example of GDPR on a mobile device. And as you can see, even though you have a small screen on a mobile device, you can still use that same concept of layering information. And a person can select what information do we collect. That's a version of being transparent. You have to let the person know how you're going to use the data, what you're going to collect, how you're going to use it, who you're going to share it with. So consent requirements. So consent has to be distinguishable from other matters, meaning that you can't have everything lumped up into one giant thing and say, I accept at the end, like we're used to seeing. It has to be intelligible and easily accessible. So if a person wants to say, gather their information, find out what you have in your system, it has to be easy for them to do that. Being clear and plain language that a person can understand, not in the thick legalese that we're used to seeing. Has to be easy to withdraw consent. And special categories are prohibited from being collected. And those would be the things that we think of in the United States as being politically incorrect. And those would be things such as race, religion, political views. Okay, and then criminal convictions would be under the authorities. So they're handled a little bit differently. And finally, child consent. GDPR allows a child age 16 and above to give self-consent. If they're below that age, unless they are in one of the European nations that has a lower age, then they would have to get parental consent. And if a European nation has an age between 13 to 16, that would be acceptable if it is in a previous law, but the GDPR will not allow it to go below age 13. This is an example of a legalese form that we're used to seeing in the United States. They'd show all of this information, and then you'd click I accept. It's not acceptable under GDPR. So here's a best practice that shows unbundling the terms and the contact. So in this one, a person can select, yes, I agree to the terms and conditions, and separately, I agree to contact permission. Well, here's another example of a best practice. On the right, you can see the Law 360's sign-up form for getting their newsletters, and you would put in a variety of information. On the left side, you have the Law 360 EU version, and as you can see, there's some differences here. There are not as many fields being collected in the EU version as there were in the United States version. And if you look at that US version, all those asterisks next to the field name indicate that that's a required field. Now, the granularity is where you can select which types of newsletters you want to receive, and that's there on both sides. But you can see in the EU version there are a lot fewer fields than there are in the US version. This is an example of the right to be forgotten as it's implemented at Facebook. All you do is you go and click that button, delete my account. So preparing for GDPR compliance. First, you'll want to find out if there are any corporate governance changes that you need to make at your organization. Do you need to assign a data protection officer or not? If so, you'd want to have that person in place as you go through this process. Next, you'll want a map of your current personal data. Where does it reside in your organization? What information do you collect? How do you collect it? And you will probably need to make some technology changes along the way, depending upon what you're already collecting and what you should be doing for GDPR. The legal review, you will want to have your changes reviewed by your lawyer, either internally or your external, whoever you use for your legal advice, to make sure that you don't have any conflicts between GDPR and any current contracts or storage data that you're doing today. You will need to train everyone in your organization, because you don't want one person in the organization answering the phone and telling somebody that they cannot have their information. That would be a violation of GDPR. And finally, of course, you'll need to adhere to all of those changes that satisfy the obligations for data processors and collectors. So there's a pretty sizable project here, but it's not insurmountable. Now, here's some resources that might be helpful to you. The GDPR official website, definitions of primer, and if you wanted to get a certification in GDPR, there's a website for that too. And of course, the full GDPR document, which can come in very handy because you can search within it to find out answers to any questions that you might have. It is quite lengthy, though. It's 260 pages, and so there's quite a lot of information in it. Here's some additional resources that might help you out as well. And finally, let's talk about some of the common questions that we receive when we're giving this presentation. One of the most common questions I hear is Britain included in GDPR? And the answer to that question is yes. So GDPR becomes effective May 25th, at least enforcement of it becomes effective May 25th of 2018. It's actually been around since 2016, but enforcement begins on May 25th. Britain, a lot of people ask about because of the whole Brexit scenario. Their Brexit will not be official until 2019. So they will have to adhere to it. And even after that, probably a lot of their companies might have European data in them, so they'll have to adhere to it beyond that as well if they do. Some people ask if small companies have to adhere to GDPR, and the answer to that is that small companies that are processing European individual data would still want to adhere to the GDPR as much as possible, but they're not going to be required to the same level of data storage requirements and logging as the larger companies are going to be required to do. So frequently people do say, now I don't store any European data. Do I really need to adhere to this? And you want to think about how that might impact your company if you choose not to adhere to GDPR. Let's say down the road, if you even have a website that's public facing and somebody from another country can go into it and purchase something, then if they're in the EU, then you would have to adhere to GDPR. Or if someone visits your store and they're on vacation and they're from the EU, you will need to be adhering to GDPR. So it's probably in your best interest, and also to reduce the risk of ever getting hit with fines, to go ahead and adhere to it as much as possible. But the controllers or the authorities that do enforce GDPR generally do take into consideration if you have done due diligence on trying to adhere to the rules or if you've totally ignored them when they decide what fines they're going to assess. And another question we frequently get is, will the U.S. enforce GDPR fines? And although that's yet to be seen because enforcement has not begun yet, I think there's a good possibility that that will be true because the United States does have a mutual legal agreement with Europe. So chances are that they probably will, but until those court cases are played out in reality and the precedent is established, we won't know for sure. All right, well, I hope you've enjoyed learning about GDPR today. And if you have any questions, feel free to give us a call here at Omega ATC at 636-557-7777, extension 2405. Thanks so much. Have a great day.